Good morning, friends. Today we are discussing the topic relating to the physical presence of the parties at the time of compromise, the physical presence of the sureties at the time of release of the accused on bail for standing as surety, and also physical presence at the time of mutual consent by divorce. So, recently, Karnataka High Court held that the physical presence of the parties is not necessary due to the COVID-19 pandemic situation, and it can be waived off temporarily. Temporarily, not the amendment has not come. Temporarily, they can be dispensed with. While disposing the writ petition number 7338 by 2020, dated 10/7/20, just 4 days back, the Honorable High Court of Karnataka, so CJ Okha, so he held that the physical presence of the parties need not be necessary for acceptance of sureties, mutual consent, divorce by mutual consent, things like that. Right, now let us come to the real situation. What happened? Right, normally let us discuss the cases. First of all, let us discuss about mutual consent by divorce by mutual consent. Right, normally under section 13B of the Hindu Marriage Act or section 28 of the Special Marriage Act 1954, the couple who are not happy to be joining in union with each other, then they will file a petition for divorce and a decree will be granted. Normally, at the time of granting the decree, the presence of the parties is 100% necessary. But now, the High Court held that it can be done through video conferencing. Of course, this was happening for the past so many years. About 15 years back itself, we had a case where the girl was staying at Chittoor and the boy was in USA and he has left her. Anyway, the divorce was granted basing on the Skype conference between the victim and her husband. So same thing now. So we have to already section 65B of the Indian Evidence Act has been amended and video conferencing allowed. Nowadays even the Supreme Court, Honorable Supreme Court, High Court and most of the courts, they are functioning through video conferencing. And in fact the criminals also can be consulted through video conferencing for the extension of remand. For that purpose only section 167 has been amended that the criminal need not be physically present before the court. He can be interviewed as his remand period can be extended through video conferencing. Right, all these things have been coming. These are all technical advancements. Now, Kerala High Court stated, so CJ, Chief Justice Abhay Okha and Justice Vishwajit, both of them, Vishwajit Shetty, so they passed the order while hearing a sumoto petition to address the various legal and technical hurdles or issues that are arising due to this COVID-19 pandemic and due to the partial functioning of the courts, because from June onwards totally almost entire nation has been going on to lockdown and therefore people are not venturing to come outside. Of course, there are persons who do not have any work and they will come outside on the roads, but normally the general public, they are not venturing, they are daring to come out of the roads. In this connection, even the courts, they are also not allowing the litigants to come to the court physically. Therefore, so these technical aspects have to be sorted out. Therefore, they filed a petition in WP number 7338. Now, let us go to the CPC. At the time of compromise decree or divorce by mutual consent compromise decree, which is held in Order 23, yes, Order 23, Rule 3 of CPC 1908. So they say that the adjustment or the compromise decree can be recorded if the parties effect compromise and the matter is brought to the notice of the court. But there they insist the presence, the physical presence of the parties is mandatory. But now the court holds that the advocate is competent to put his signatures on the compromise terms. Of course, if we get the, there are little variation. Now, the parties, they have to file the affidavit that they have agreed to the compromise suit, and they have to put the Aadhaar card, and they have to give the Aadhaar card and PAN number, and also an affidavit stating that they are not able to come to the court due to the pandemic and their presence may be dispensed with, and the lawyer may represent them. How the lawyer can represent them? Please remember, go back to our famous Order 4 Rule 3, which says that lawyer is the recognized person. That is why, while discussing how to file the wakalat nama, at the time I told you. So lawyer is the competent person. He can be recognized as recognized as the recognized agent of the parties. Therefore, the parties need not be present. For this Honorable High Court of Karnataka, they relied on a previous decision. Bairam Pestonji Gariwala versus Union Bank of India. In this case, the conclusion is that advocate has the authority to sign the compromise petition. So this is a leverage, actually an exception. Now, so normally tomorrow some people will come and apprise the Honorable Court that they have not at all been informed about the compromise, they are not aware of the compromise. Things may happen like that also. Because very recently, you might have seen in the press, then Visakhapatnam, one advocate, he has taken the complainant party person, 3 persons, so cheating. He has impersonated the 3 complainants and made them before the National Lok Adalat day, before the judge. And the judge, luckily, one of the members, he was an advocate actually, he got a doubt and he verified the Aadhaar card and found that these people are fictitious people, and now immediately the advocate has been arrested, he was landed in jail. These things also do happen. It's not that మనం చెప్పినంత బాగోదండి. లాయర్ గారు కంప్లైంట్ తరఫున కంప్లైంట్ అని చెప్పి 3 డూప్లికేట్ పర్సన్స్ తీసుకెళ్ళి పెట్టాడు. లక్కీగా ఆ బోర్డులో ఇది ట్రిబ్యునల్ బోర్డు ఉంటుంది కదా, లోక్ అదాలత్ బోర్డులో 3లో ఒక అతను లాయర్ ఉండే, ఆ లాయర్కి అనుమానం వచ్చి వాడి ఆధార్ కార్డు వెరిఫై చేస్తే పేరు టాలీ కాల, లాయర్ గారు జైలుకి వెళ్ళాడు. సో ఎస్, డెఫినెట్లీ. సో టు అవాయిడ్ సచ్ ఎలిగేషన్స్, ఇట్ ఈస్ అడ్వైజబుల్ టు గెట్ ది అఫిడవిట్స్ ఆఫ్ ద పార్టీస్. జస్ట్ నౌ ఐ టోల్డ్ యూ. Court, of course, can always exercise its power of Rule 103, presence of the parties whenever necessary, or they can ask the parties to be present through video conferencing also. Yes, this can be done. The court has got always the authority and nobody can question the same. Right. Now, our important point, acceptance of the sureties. This has become a big problem. No doubt, the person, he will be arrested, he will be sent for judicial remand, and we file a petition for the bail. The bail is granted. The bail is granted with the condition that he has to be released on bail on producing 2 sureties for a sum of 25,000. Like that, the bail order will be written. Then the sureties, yes, the sureties will be there, but the sureties should be physically present previously to say that yes, we are here, we will bring the accused to the court as and when required by the Honorable Court. That is the assurance they have to give, and then only they will be regarded as a standing surety for the accused. But now, what's happening? Well, for that there is so much of thing. That surety must have certain property. That property should be actually, if he has got a house, he has got a house certificate or taxation certificate. If the land is there, some certificate of all these things he has to have. The Aadhaar card, PAN card, everything. They will require so many things, photographs, all these things. But still, so many mischiefs are going on. Yes, we have seen right in front of the office there is an advocate and he was the secretary of the bar association at that particular point of time. But since he produced a fake surety, of course the court wanted the local surety, but he has produced a surety from Jampani village of Guntur district, which was turned out to be fake because he has already stood as a surety for so many persons, and he doesn't know the accused in person. He does not know who the accused is. Simply, they are called as stock sureties. They came there, he was caught, and a case of 420 was registered against him. Of course, he is no more. He committed suicide, of course, due to some other reasons. Anyway, these problems are also there, right? So now, regarding the acceptance of sureties, these are the problems. But now, the advocate can produce the bail bond signed by the surety in the prescribed form along with the affidavit of the surety. Just like now, the sureties need not be physically present or physically appear before the court. They can send an affidavit, and they can give the photos, they can give the Aadhaar card, they can give the PAN card, and they can give the property certificate, all these things through their advocate. So the PAN card, Aadhaar card, proof address, they shall be produced, and please remember, they should be self-attested. Self-attested means the person, he has to attest that this is my Aadhaar card, this is my PAN card, this is my proof of identity, like that. And in the court, the advocate has to identify the signature of the surety. That means he has to sign before the below the signature of the surety. He has to certify, he has identified the signature, and he has to produce the recent photo of the surety, not when he is having a clean shave, or when he has gone to Tirupati, or when he is a 20 years boy, like that. So they have to produce the surety's photo of latest, maybe 2 or 3 months back, right? Of course. The court, if not satisfied, the court also can conduct some initial inquiry under section 441, clause 4, I think, clause 4 of the CRPC. Because during this COVID-19, there is literally an embargo on the entry of the litigants in the district court, even in small courts premises, because all the people are getting affected with the corona. So many, even the judges are affected with the corona positive. Therefore, the advocate is better that even the advocates are also not allowed, only e-filing is allowed. But in important cases, yes, through video conferencing or by filing the so-called before the drop box, you can file, because it is a right for the accused. When he was ordered to get bail, he has to go out. He cannot languish in the jail. So that right will be accepted. But only thing is, previously they used to ask for the physical presence of the sureties. Nowadays it's not necessary. But friends, think that don't think that it is so easy to escape. Definitely they have to give the affidavit, they have to give the recent passport, they have to give their Aadhaar card, they have to give their PAN card, they have to give their proof of address. All these things will be there. Only thing is the physical presence. Right? So at least this is a very good leverage. Otherwise you have to wait before the court till the judge comes. The judge will not stir out from the house. They will be busy. So to avoid all these problems, definitely it is a very good idea. So this is the thing. So mutual consent, and we discussed about the so-called sureties things, and like that. So whenever any compromise is affected, the advocate can represent the client. Right? Okay, this is the crux of the judgment. Very good judgment. Of course, for everything, the negative things also there. So for the final year students, while discussing the professional ethics, we have discussed a very famous case. So where the advocate has in the name of the complainant, just like he has signed the compromise petition, he has taken away the money, he did not give it to the complainant. Okay, such things also do exist, but in general, this is a good practice, and instead of making them light around near the corridors of the court, it is better not to ask for the presence. If at all necessary, yes, the court has got every power to summon them or to inquire them through video conferencing also. So please remember, video conferencing has become the best tool for conducting the proceedings of the court. Thank you.